How do you know if your case is ready for settlement negotiations? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Almost every single injured patient who comes to me says, listen, I want this to be resolved quickly. I don't want to have to go through 2 or 3 years of litigation. I want this done. It's clear cut. I know exactly what happened. They should know exactly what happened. There should be no issue whatsoever. This should be wrapped up in a few days, a few weeks, or at most a few months. Well, is that really what happens? The answer is no, that's not really what happens. So, what does happen? I'll tell you what happens. And to answer the question that I raised in the beginning of this video, at the very beginning of your case, the defense knows nothing, none of the details about what actually happened to you. If the defense doesn't know any of the details about what occurred to you, how can you expect them to go ahead and enter into settlement negotiations at the very start of your case? It's impossible. There is no reason for them to go ahead and negotiate because they know nothing about your case. Now, shortly after your lawsuit is started, we deliver papers known as a complaint to the people whom you are suing. That would include the doctors, the hospital staff, and anybody else that you are suing. In that instance, the only thing that they have to go on is your name and some vague general allegations of malpractice or negligence about what occurred to you. They know very, very little at that point. So what typically happens? Shortly after we go ahead and start your lawsuit, I might get a call from one of the defense attorneys, and most of the time it happens to be one of the senior defense attorneys who I might have worked with in the past on another case, who says, hey, Gerry, listen, I'm representing Dr. Jones. I see you just sued him. Can you tell me a little bit about what this case involves? And my answer is always, of course. Let me tell you, this is a case involving a 37-year-old, and now I go ahead and tell him briefly what the case is about and what his client's involvement is. Now, why is that important? Because it gives him a heads up about what's coming down the road. It gives him an idea about what to look for, so now when he calls his client, the doctor, Dr. Jones, he can now have a semi-intelligent conversation and ask him, hey doctor, do you remember this guy? Do you remember anything about the care and treatment you rendered to him 2 years ago? And now he'll have a brief conversation about some of the details that the doctor does remember, and now at least he has a basic understanding of what went on. He doesn't know any of the details yet. At what point is the defense now going to have a better understanding? Well, after all of the people whom you have sued have answered the allegations in your lawsuit, which, by the way, they're going to deny all of your allegations, and they're also going to point fingers at you, claiming that you caused and contributed to your own injuries. At that point, I am now required to prepare another set of documents that detail the specific allegations we are making against each and every person and entity that you have now sued. That's a document called a Bill of Particulars. And that document literally itemizes all of the claims that we are making. What was the negligence? What were the specific wrongdoing events that occurred? What injuries did you suffer as a result of all of that wrongdoing? And once I take that document and now deliver it to the attorneys who represent the various doctors and hospital staff, now they will have a much better understanding of what type of case this is, what actually occurred, what we claim occurred, and what we claim should have occurred. At that point, are they ready to engage in settlement discussions? The answer is absolutely not. Now you might be thinking, why not? It's because they don't know all the details of what occurred to you. They don't know how your injuries have affected you on a daily basis. They don't know about the things you can and cannot do. They will get, and they will need to get, copies of all of your medical records. Not just the ones that you think are important, but they're going to go back a number of years to go ahead and scour through your records to see what your medical condition was like before the event occurred, as well as what your medical condition was like after it occurred. So now the defense will spend a considerable period of time accumulating and gathering all of your medical records, just like we did at the very beginning of your case. Okay, you might say, after they get all your medical records, will they go ahead and start negotiating? The answer most likely is no, they won't. And now you want to know why not. Now they have the allegations, now they will have a bill of particulars, now they will have your medical records. Why won't they start negotiating at this point? Because they want to hear from you. They want to hear in your own words exactly what occurred And they want to know, importantly, what things you can and cannot do. They want to go ahead and take your testimony and question you in a process known as a pretrial deposition. It's a question and answer session that's given under oath typically in your attorney's office or on a Zoom video call. And the answers that you give represent your sworn testimony. And that's critically important to lock in your testimony, because now they will have much more details about the events that transpired after you go ahead and testify. And you say, okay, after you give your deposition, your pretrial testimony, will they be ready to negotiate? The answer is maybe. Now, why do I say maybe? Because they may want the doctor to go ahead and testify as well as the nurses and any other hospital staff. They want to know what they will testify to. And the expectation and the hope is that once these people, these doctors and hospital staff, have gone ahead and testified in their pretrial deposition, hopefully now it will become crystal clear of exactly what happened and what injuries you, the injured patient, have suffered as a result of the wrongdoing. At the end, at the conclusion of these depositions, now the defense is in a much better position to have a true understanding of what did occur, or importantly, what didn't occur. And now they can make an assessment about whether or not to begin settlement discussions. Having said that, does that mean that they will go ahead and start negotiating? The answer is no. But what they will do is they will begin to analyze and start to evaluate your case to see whether or not it's worthy of settlement discussions. So how long does that process take? Well, it could take anywhere from 2 to 3 years from start to finish in a medical malpractice case in New York. But the negotiation process could literally start at any given point in your case. It could start after we begin your lawsuit. It could start after I serve a bill of particulars. It could start after you have been questioned in your deposition. It could start after I have questioned various doctors. It could happen at any point if it becomes clear-cut and so obvious about what happened. Now remember, just because you believe that it is a clear-cut case doesn't mean the defense agrees, and doesn't mean that they will see it our way. We would like to think so, but that's not what occurs most of the time. So after depositions, will they go ahead and start settlement negotiations? The answer is maybe. But most often the answer is maybe not. Now, after your case gets put on the trial calendar, and now it's going to sit there for many, many months before we get called for trial, will that prompt the defense to begin settlement negotiations? In many cases, the answer is no. Those negotiations may not happen until we get very close to trial. And in that instance, now it may be 2 years after you've started your lawsuit, 2.5, 3 years. And in that instance, you are frustrated, you are exhausted, you have now been through the ringer with this litigation, and you don't understand why, if something is so obvious, why they haven't gone ahead and started to negotiate. And the answer is, they may go ahead and start negotiating. But even if they do, there's no guarantee your case will settle. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.